The next matter before the court is State of Ohio versus Robert Johnson. Each side will have 15 minutes. As you know, the appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, please let me know how many minutes you'd like to reserve, and I'll give you a signal when you get there. You may proceed when you are ready, and if you would, please use the front lectern.
I would like to reserve 5 minutes for rebuttal. Thank you, Your Honor. May it please the court. My name is Stephen P. Handel, and I represent the appellant Robert N. Johnson. And Mr. Johnson was convicted of one count of theft of firearm, which is a third-degree felony. And the reason why it's a third-degree felony is because it's specific. The statute that which he was convicted under specifically calls for a third-degree felony for a theft of firearms. And on top of that, he was also convicted of a specification, a firearm specification that required an automatic 1-year prison sentence in addition to whatever was imposed for the third-degree felony. That firearm specification says that if you're in control of a firearm in the commission of an offense, then it's going to be an additional 1 year automatic. Now, under both statutes, under both the specification and the theft of firearm provision, now the theft of firearm provision does not take into account the value of the property. It's just that if it's a firearm, then it's a third-degree felony. However, the catch to that is that it requires operability of a firearm. The state did not present any evidence that the firearms in this case were operable. And they could have presented that. It wouldn't have taken that much longer to do. They could have simply asked the owner of the guns to say, hey, have you fired these lately? Do they work? They didn't ask those questions. And now the state's trying to say, well, the operability can be inferred from the circumstances. And certainly there are cases out there where the inference can be made, but it cannot be done in this one. The cases where the inference has been made involve, like for example, there's a 1990 case that the state cited where the person was robbing a gas station or convenience store with a gun in his pocket. And that's where the Supreme Court inferred operability. But here, we don't have an offense of violence here. We're just talking about outright theft, where Mr. Johnson stole the items so he could, which he later sold them so he could use the money to get high, which is unfortunately sad, but that's what it was. However, but the issue here is that because the state did not present evidence of operability, the theft offense should be reduced to a 5th-degree felony because the state did present evidence of the value of the item being between $1,000 and $7,500. So he should have only been convicted of a 5th-degree felony, theft, and no specification. And at that point, he would have been subject to a maximum 12 months in prison, possibly be put on probation. But instead, because of the errors of the trial court of being convicted of a 3rd-degree felony offense and the specification, he got put in prison for a total of 2 years, 1 year on the offense and 1 year on the specification.
So let me make sure I'm following you, because as I understand the facts, and we've had a couple of these cases, I want to make sure that my head is in the right case. This is the couple who lived at the home of the gun owner.
That's correct.
Who then stole the weapons. There were more than one.
There were more than one. They stole several.
Each attempted to take them and sell them, but he had a felony record. Your client did.
Right.
So they wouldn't sell it.
Correct.
They would not purchase it from him.
Right.
His girlfriend, whom he said was his wife,
right,
came, and they said, okay, we can work with you.
Right, and so she was the one that officially sold the items to the shop owner.
Right. Is this a pawn shop?
It was something like that, where they were paid cash for the guns, and there was ammunition in there too. And that's the other thing too. The state never presented evidence about the ammunition as to which gun, what caliber.
That was one of my questions. Which of the guns did the ammunition fit?
There is no evidence presented as to what caliber the ammunition is and to which gun they would belong to or would fit into or be fired out of. Nothing to that effect was presented. So I think what we have here is, lots of people collect guns of antiques, like Civil War era guns, and so on and so forth, including ammunition too. And oftentimes those guns do not work; they are not operable. And so, because guns are oftentimes a collector's item for people, we can't tell the difference between whether these firearms were just for collector's item purposes and as antiques and perhaps not operable, or they were in fact used for operations. There's nothing presented to distinguish them.
So, I thought I recalled that the person who purchased the guns testified that he was not purchasing the gun for resale, but for his own personal, to keep the gun personally.
Right.
And the state is arguing that he would only do that if he believed that the guns were operable. Where does that take?
I know the state's taking that position, but at the same time, the purchaser could have very well purchased them for his own collection, again, for antiques. And again, there's no evidence to distinguish that these guns were not purchased for antique purposes, but were purchased for actual use. And nobody testified as to testing the firearm. The purchaser never testified to going to a range and test firing them to make sure they work. There's nothing presented on that. So because the state did not meet its burden of production on that issue, the court has no choice but to rule in the defendant's favor that the firearms were not operable, and at least there's not sufficient evidence of operability, and therefore the theft offense should be reduced to a 5th-degree felony, and then the specification be removed as well. And if there's no more question on that issue, I can move on to the next one as well. And I would like to add one more issue on the state cited State versus Blue, which this court ruled on in 2011, and I like to point out, and they were talking about making the inference and circumstantial evidence on operability. In that case, those firearms were tested and fired, and and there was testimony on that, and they were rendered operable for that reason. And again, that nobody tested the firearms, nobody testified about firing these guns and making sure that they work. So we can't just sit here and assume and speculate, and I think there's not enough evidence to even make the inference. And all that can be done now is just speculation, and if that's what we're reduced to, then Mr. Johnson should have received an acquittal on the specification and a reduction of the degree of the theft offense from a 3rd degree to a 5th degree. Moving on to the constitutional issue regarding the specification and the theft of firearm offense. The theft of firearm offense, in order to make it a 3rd degree felony, it specifically requires that you steal a firearm, it's a 3rd degree felony, automatic. We don't care what the value of the firearm is. And then the specification says, well, if you're in possession or control of a firearm in the commission of the offense, which requires possession and control, then he's receiving a double punishment for the same act. And to steal a firearm, you have to obtain possession or have to obtain control over that firearm, which is then the same thing as the specification. And so, pursuant to the Supreme Court's holding in State versus Wilson, that because the same act is committing the offense and the specification, that he shouldn't be receiving double punishment for that, and also the state can pick and choose who they want to indict on the specification.
I have a question. How could it be the same act when in the present instance it was this act, but in the specification it was the 15th or the 20th or the 7th or the 60th time this person possessed a weapon after being told not to? How can it be the same act? It's not. This is the 15th act, but this is this act.
In order to steal the firearm, he has to obtain control of it.
This time.
At least at some point.
This time.
At some point, he has to obtain control of the firearm without the owner's permission. So, and we're not disputing that that's what happened. And although we're disputing the operability, but we're not disputing that he took this item without the owner's possession. and which, you know, we feel should only just be a fifth-degree felony. But the specification then says, well, if you're in control of the firearm, you get tagged with, you can get a 1-year prison sentence on top of the firearm theft offense, which requires the same thing. It's just duplicative.
The difference is that having, correct me if I'm wrong, the difference is you did it today, so this is the present offense. But presently, you knew past not to do it again. So the other offense is that you've been told before not to have a weapon, and you sort of do it again. So isn't that compounding? It's not the same offense. It's a different offense. Isn't
Well, I think if, let's say if he was prohibited, let's say like a weapons under disability offense, where if you're prohibited to own a weapon, I would think those would be allied offenses, like a weapon under disability and a theft of firearm and something like this would be allied offenses and would merge. So, and therefore would not receive a double punishment. I think that's the ultimate, where we're disputing this whole thing is that he's receiving double punishment for the same conduct. So, you know, I would like to reserve the rest of my 5 minutes for rebuttal. Thank you.
May it please the court, my name is Natasha Ferrari and I represent the appellee, the state of Ohio in this matter. First, with regard to the operability of the firearm, the state doesn't dispute that there was not direct evidence of the operability of the firearm. There wasn't a BCI report. The owner of the gun did not testify to the fact that he had fired the weapon. That's not in question. The state, that's not in the record. However, the state would argue that circumstantial evidence of the operability of the firearm can be found within the record, and that the trial court had to look at the totality of the circumstances in order to determine the operability of the firearm. Here we have the evidence that the state would point to in the record to support that is that the owner of the weapons testified that he actually kept the firearms in a storage area in his bedroom, and that bedroom was off limits to the other individuals that were in the residence.
How many other weapons were in that same area?
There was several, let me see here. I think there was approximately maybe 9 weapons that were taken at this point. That's an approximation. I would.
Were other weapons found elsewhere in the house that were tested or looked at?
I'm sorry, Your Honor.
No, go ahead.
And not that I didn't. There was no other testimony in the record of other weapons within the residence or anything to that effect. It was just simply with regard to these particular weapons that were stolen here.
Well, what's the,
I'm sorry, no, you go ahead.
I'm not sure of the evidentiary value on this issue of the fact that he kept the guns in a storage area in his bedroom that is off limits. I mean, most people's bedrooms are off limits to guests. The fact that the guns were there was so what?
The state would argue that it's a culmination of all these different factors, that he didn't keep them out just for, you know, anybody to have access to them. He was actually putting them away in an area that other individuals didn't have access to in order to take them, and that he actually excluded others from that area. So that's just one factor in that.
So what's the probative value of that on operability?
That he was trying to keep people away from these firearms. I'm not sure if, and I apologize, you know, just to keep others away from them. Like, for example, and I'm not saying that that's the circumstances in this case, that, you know, if you have a person that has a child in the home, you keep it away so that child does not have access to a weapon that could ultimately be used accidentally and cause injury to another. So that's kind of the view that I'm looking at it through, is that you're trying to exclude others from having a weapon that could be used either accidentally or assumably maybe even against the particular homeowner there.
Do we know if that area, I think it was there ammunition stored, was it a locked area?
I do not, there was not testimony, I'm sorry, Your Honor.
No, go ahead.
I apologize. From my recollection, there was not any testimony in regard to how large the area was, and I do not recall it stating that it was locked. But I do recall that Mr. Wilbur stated that he also kept ammunition in that area, and that actually ammunition itself was also taken with the firearms that were taken.
Thank you.
And you would agree then with the statement of your colleague here that no one asked about whether the gun had recently been fired or matched the ammunition with the weapons?
I would have to agree that there was not questioning with regard to that in the record, Your Honor.
So how do we know, I mean, I guess there could be a situation where you have, for example, 38 caliber weapon and ammunition that fits that weapon, and they're in close proximity.
Correct.
You know, they're together. And then perhaps an argument could be made that that's because it fits the weapon and it can fire. But here you've got a couple of different types of gun. How do we know that, you know, the ammunition would make it more likely than not that any one of those weapons would be operable?
Unfortunately, there was not testimony to that fact, and that definitely would have assisted in this analysis on the behalf of the state. And
You sort of take what you get.
correct, Your Honor. So, I mean, you know, that obviously would have been much more helpful on this behalf of the state here. So, I mean, the state is not arguing that this is not exactly the perfect scenario with regard to the operability, but in looking at the circumstances that were present, would argue that there was, in looking at them all in the totality, that it could be inferred from the evidence that these guns were in fact operable. And just in looking at the constitutionality issue, issues with regard to constitutionality should be raised at the first possible opportunity to do so, and in a criminal case that should be in the trial court. And failure to do so would act as a waiver of that issue. Here, the record is devoid of any issue of constitutionality raised by Mr. Johnson. There was never a motion filed, never an oral objection made at trial or any pre-trial of that nature. Therefore, the state would argue that, in fact, he waived that issue on appeal because he had the opportunity to do so and he failed to.
He's arguing this under the plain error standard, or not?
I don't recall at this point, I'm sorry, Your Honor, I do not. But even in viewing that under plain error, it was his obligation in the trial court to establish that there was in fact some sort of disparate treatment here. However, he presented no evidence at all with regard to that fact, no evidence that other defendants similarly situated were not being prosecuted for the same type of offense, and that for some reason he was intentionally targeted by the state. There was nothing there. That was his burden. That's what he had to show in order to come to this issue with regard to constitutionality. He failed to do so. Therefore, that issue is actually a non-issue at this point. And his reliance on the Wilson case, the state would argue, is misplaced because in Wilson, that dealt with two actually separate issues versus what we have here, which was a count of theft and a specification. And the state would point to the court to State versus Mail, which was out of the 5th district that dealt with an offense and the attached specification. And in that particular case, they found that in fact does not violate equal protection because the specification is just a notification to the defendant that the state is intending to get this additional or a different punishing scheme with regard to the offenses that he committed. Therefore, even just reviewing the evidence and based upon an analysis under the appropriate standards there, Mr. Johnson has not met his burden, and therefore the state would just request that this honorable court uphold his conviction and sentence in this matter. There are no further questions. Thank you, Your Honors.
I just have a couple brief remarks. The reason why the theft of a firearm is that offense is elevated to a third-degree felony, regardless of value, is because of the legislature's concern about people stealing live operating firearms. And there is certainly a policy issue with that, and that they don't want people stealing guns that can fire and then go commit crimes. So therefore, it makes sense as to why that offense will be a higher degree felony regardless of value. But again, the important element is the operability, because a gun that's not operable can't be used to shoot somebody and commit any other related offenses related to that, which is what the legislature is ultimately trying to deter. And so if the state doesn't present operability, then Mr. Johnson cannot be convicted under that third-degree felony theft offense, but only under the fifth-degree felony theft offense in relation to the value of the property that he took.
It looks like in looking back at your brief that you raised plain error with respect to the first assignment of error,
Right.
that you just addressed, but I did not see any reference to it with regard to the constitutional issue. Am I correct in that?
When I wrote the brief, I think what I did was I operated with, when I raised plain error the first time, that I guess my thinking that was going to carry through the rest of the brief to all the issues. And so that's what I meant to do, and as I look back, I realized that I did not specifically raise it for the constitutional argument, but by raising it in the first assignment of error before all the other issues, my intent was to have it carry through the rest of the brief, and and at least recognizing that the issue wasn't raised in the trial court level, and but it still qualifies as plain error. And I think regardless, since plain error is ultimately plain error, this court can still decide the issue regardless whether plain error is raised or not, and because it gets to the substance of the case. And it gets to the issue of, but for the error, would the end result have been different? And in this case, I say absolutely. So that's all I have. I can answer any other questions the court may have.
Thank you for your presentations today. We will take the case under advisement, send you a copy of the written opinion when it's issued, and you can always monitor the webpage if you're curious. Thank you and have a good day. We are adjourned.